Chairman, you're live.
Okay, we'll go ahead and get started. So we're good with the YouTube and the Zoom and all that stuff? Okay. All right. Well, folks, we'll get started this morning. At our last meeting, we had House Bill 141 presented to us by the sponsor, and I don't see him in the room. And we held off public testimony until today, so we'll pick that back up. Then we will hear House Bill 189, monthly ad valorem tax revisions enforcement. I think Representative Crago is going to present that for us committee. And then the last bill will be Speaker Barlow's House Bill 123, mine reclamation, disposal of materials, sort of an add-on from what we did with wind turbines, I believe. So with that, we'll go ahead and call the meeting to order and roll call, please.
Representative Baer.
Here.
Representative Burkhart.
Here.
Vice Chairwoman Duncan. Representative Ayer.
Here.
Representative Gray. Here. Representative Heiner. Representative Sherwood.
Here.
Representative Western. Chairman Greer.
Here.
Thank you.
Okay. So with that, we will take testimony on House Bill 141. I see a smattering of folks. And so the governor's office is taking their prerogative to come first. Please come forward. Mr. Luthi, Speaker.
Good morning, Mr. Chairman. I guess that is a prerogative. I just jumped up first, but I appreciate taking that. Mr. Chairman, members of the committee, thank you all for your efforts. Just in general, the governor wishes you all well as we sprint into week 2, 3, and eventually 4. So it's a great time. Governor has asked me to come today and tell you, yes, he is very supportive of the revisions to House Bill 141. You might recall last year, the bill was specifically targeted to somewhat of a narrow litigation opportunity. And that was if other states took efforts to actively restrict the ability for Wyoming to produce and use coal in coal-fired electric units, that the governor could authorize the Attorney General's office to intervene and litigate in those kinds of cases. The bill also provided that we would send a report to the Minerals Committee every fall about how we're doing. And October 1, we sent a report and we said, we haven't done a thing. And so that, helped produce a little bit more discussion of, well, why haven't you done anything? And the reality is we were limited. States weren't taking many actions. The state to our south that had generated, this bill originally, frankly, the their Public Utilities Commission had actually said the state of Wyoming couldn't intervene in there. And nothing else was done, and there were other changes that made that situation where it's much more livable as we deal with the Laramie River Power Station. But the questions still remain. How do we make this more viable? Well, easy answer is the amendments that you've been looking at. And one is, well, let us sue the federal government. And then sometimes there are third parties that also generate certain areas of litigation that allow that if we could intervene in, it could be very useful. Just point out to you our knockdown drag out fight with EPA as we dealt with Jim Bridger. It's still ongoing. Hopefully we have now presented a plan to them that they will find acceptable. But that's been litigation on regional haze. It's been going on for years. So I know some will say that, well, Mr. Luthi, just last year you've sent a letter saying that bill was narrowly confined and therefore the governor wasn't going to veto it. What has changed? And frankly, Mr. Chairman, this gives me an opportunity to use one of my favorite phrases when we deal in the legislature. That was then, this is now. So with that, Mr. Chairman, members of the committee, if I could answer any questions for you.
Good. I'll go Representative Heiner, then Duncan.
Thank you, Mr. Chairman. Mr. Luthi, thank you for being here this morning. In the original bill last year, we appropriated some funds to help in the litigation. And apparently you haven't used any of those funds yet. So why do we need to appropriate additional funds in this bill?
Mr. Chairman, Representative, my understanding is you're not. It's just that we're just amending how those funds can be used. Those funds that were appropriated last year actually said could be carried over.
Okay, Representative Duncan.
Thank you, Mr. Chairman. So, Mr. Luthi, doesn't the governor's office already have authority to do all of this? So why do we need to do this?
Mr. Chairman, Representative Duncan, thank you for that question. Absolutely, we do, but we don't necessarily have the resources to do it. This provides, as I say, that proverbial arrow in the quiver, another one that we might be able to use in the future.
Yep, Representative Bear.
Just to follow up to that last question. Thank you, Chairman, and thank you again, Mr. Luthi, for being here. This arrow in the quiver, does it also include the ability to hire outside counsel that might have more expertise in a particular area that you may enter into a lawsuit in?
Mr. Chairman, Representative Bear, I suspect that it does. I've looked at the language. I do believe it's loose enough that if the AG needed to do that, they would. That isn't always our first choice because we'd rather use the resources we have in state.
Committee, any further questions? Yep, Representative Gray.
Thank you, Mr. Chairman. Mr. Luthi, where are we on getting the coal export facility done in Washington State, and how are we continuing to pursue that?
Mr. Chairman, Representative Gray, since the major proponent of that particular facility went bankrupt, my understanding that nothing has been done on the private side, so there's been nothing for the state to support.
Yep, Representative Gray.
Thank you, Mr. Chairman. Has the governor's office corresponded with the state treasurer about possibly using public funds to get that moving?
Mr. Chairman, Representative Gray, I have to admit, I do not know the answer to that, but I will find it.
Okay, committee, any further questions? Right, Mr. Luthi, thank you.
Thank you.
Appreciate it.
Mr. Chairman, members of the committee.
All right, so who wants to testify on this? Okay, yeah, Shannon, come on up.
Thank you, Mr. Chairman, members of the committee. Shannon Anderson on behalf of Powder River Basin Resource Council, and we oppose the proposed expansion of this fund. Last year's bill was really about Wyoming initiating original litigation against other states and using that original jurisdiction before the US Supreme Court under the Commerce Clause theory. That's what last year's bill was about. This year's bill is dramatically different. It's a great expansion. And we would ask you as stewards of the public resources of Wyoming to think about the use of this fund. The proposed expansion brings the scope of litigation much more in line with cases the Wyoming Attorney General's office is already funded to do and is already greatly involved in doing. So this just duplicates funding already available to our state's lawyers. There's no identification of additional employees in the AG's office. As we heard earlier, there may be outside counsel that's hired, but there's no restrictions or reporting on any of those consultants. And we really just urge you to think a little bit more before you expand this fund to the level that it's being expanded. If the Attorney General's office determines they don't have the resources to pursue the litigation contemplated by the bill at the time of litigation, they can certainly bring a recommendation to you then. I think you're working something called the budget. That's normally a process where the Attorney General's office can bring those recommendations to you. This bill really puts the cart before the horse, creating a fund for litigation that does not yet exist. If the bill moves forward, we ask you to consider the amendment that passed the House Appropriations Committee last year, and that was reducing the fund to $500,000. And we also ask you to consider additional transparency regarding the reporting and evaluation language by asking you to strike the language on page 4, lines 10 through 12. And that reads, "The governor and attorney general may present the information required by this paragraph in executive session." We urge you to strike that language, but because we believe that the public should have access and transparency to how the state's dollars are being used, what litigation may be pursued with this fund, and other transparency of the use of the money. And finally, Mr. Chairman, I would just like to correct for the record a couple of things. The first is a statement just made by Mr. Luthi about the regional Hayes litigation that's been ongoing in the 10th Circuit Court of Appeals. The Jim Bridger power plant is not part of that litigation. It never has been. There was never an appeal related to Jim Bridger. So it's not actually part of that litigation. And then the second piece, there was a statement made by Representative Heiner last Friday, similar statement about the Laramie River Station part of that case. I would note for the record that Basin Electric actually brought that appeal. It was not brought by a third-party conservation group like us. So just so you're aware, we haven't initiated any of that litigation. So it's been brought by other people or not directly involved. So thank you. And with that, I'd be happy to answer any questions.
Okay. Committee, any questions from Ms. Anderson? Representative Gray.
Thank you, Chairman Greer. Ms. Anderson, have you thought about, I just want to see if you've thought about maybe something we're missing on getting this coal export facility. Is there any legal arguments, creative legal arguments that you've thought of that maybe we haven't employed on that?
Yeah, Mr. Chairman, Representative Gray, unfortunately, I think you're stuck with the answer Mr. Luthi just gave you. The company went through bankruptcy. They through the bankruptcy process, all the rights and title to all the property, the permits, all of that was sold and given up in the bankruptcy process. So there's not anybody there right now to pursue that port. That's my understanding anyway. And I think, constitutionally, of course, you run into problems if the state would directly fund a project like that or things like that. I would note that there is still the coal marketing fund that's out there, again, is a source of funding for the state to market our coal resources. So there is some funding out there, but I don't know how successful it would be in the port issue.
Any other questions? Okay, thank you, Ms.
Thank
Anderson.
you.
Do I hear from industry at all? Go ahead, Travis. You haven't seen you move that fast in a long time.
Thank you, Mr. Chairman. Travis Detaille with the Wyoming Mining Association. I did have a couple beers last night, so I'm actually moving pretty.
I thought there was a plate of, I thought there was a plate of wings sitting up there.
Yeah, maybe this afternoon. Mr. Chairman, members of the committee, Travis Detaille, Wyoming Mining Association, we support the bill, and I would stand for any questions.
Any questions for Mr. Detaille? Yep, go ahead, Representative Duncan.
Thank you, Mr. Chairman. Mr. Detaille, is this necessary? Don't we already have the funds and the capability to already do this?
Mr. Chairman, Representative Duncan, I would echo what Mr. Luthi said. It's another tool in the toolbox, and it's up to the governor's discretion whether to use it or not. We would hope that he would in the right cases, and yes, I think it's necessary.
Thank you.
Yep. Any further questions? Okay. Thank you, Mr.
Thank you, Mr.
Detaille.
Chairman.
I can't help but raz, yes, so anyway, please come forward.
Good morning, Mr. Chairman, members of the committee. I'm Sean Taylor with the Wyoming Rural Electric Association. We also support the bill. You may remember last year when we presented on the last year's bill, it was because of a situation that happened down in Colorado. And Representative Haraldson, Representative Duncan were at a meeting with one of my co-ops and got kind of an inside look on some things that were happening in Colorado that could potentially impact Laramie River Station. And so the initial bill was brought. This bill we support, and to Representative Duncan's question, if I may, last year we kind of talked about the bill sending a message, and it was sent and it was heard. After it got through and signed in law, I got phone calls and emails from my counterparts all across the country going, "What is this bill that you did in Wyoming?" And I told them about it. So it sent the message. Whether the right people got it, I don't know, but I think this bill is just another message saying, hey, we're gonna continue to protect and try and market our coal resources. So with that, I'd stand for any questions.
Yeah, Representative Duncan.
Thank you, Mr. Chairman. Mr. Taylor, the last bill was very narrow and focused, so it was very message on task. This is so broad. So I just question how effective it's going to be. And we already have testimony saying that it wasn't used and nothing's happened. So again, is this, last year I supported because it was very narrowed and it was a very specific message. This one is way broad. So I'm just concerned that it's not going to do the effect that we had hoped like it did last year.
Mr. Chairman, Representative Duncan, I appreciate that, but I think the message part of it is still the same. It's just to a broader audience now. Last year's bill was, hey, Colorado or whoever, if you're going to try and do something to impede our ability to market our coal resources, we're on to you. This just broadens that message to other folks that have and probably will continue to impede our ability. So I just think the audience is just bigger. The message is the same.
Yep, go ahead.
Thank you, Mr. Chairman. Who's our audience in this one? Mr. Taylor?
Mr. Chairman, Representative Duncan, everybody. I mean, anybody that wants to try and come in and tell the state of Wyoming what to do with our coal resources, if it's through litigation or legislation or regulation, we're just want to be prepared.
Okay, any other questions for Mr. Taylor? Okay, thank you.
Thanks.
Anyone else wishes to testify on this matter? Not seeing anyone move. Okay, with that, I'll close public testimony. What's the committee's pleasure? Moved by Heiner, seconded by Bear. Before we go in, just Representative Heiner, just I want to answer your question more clearly. Last year was $1.2 million was appropriated that would revert on 2030. So there's not an additional appropriation. This is the same pot of money that has already been appropriated and is sitting there, just so we understand that. Yeah, okay. Okay, committee, let's go ahead. We'll work the bill as we do. So anything on page 1? Page 2? And Representative Sherwood, you just got to jump in as I'm looking down. Okay, page 3? Page 4? Okay, Representative Duncan?
Thank you, Mr. Chairman. I propose an amendment or move an amendment for line 10 after act, striking the last sentence, the governor and attorney general. So that would be the rest of that line and then all of line 11 and all of line 12.
Is there a second?
I'll second.
Second by Sherwood. Okay, discussion, committee?
Mr. Chairman.
Okay, go ahead, Representative Burkhart.
Thank you, Mr. Chairman. Mr. Chairman, I don't know about that because there are times in legal matters where you really don't want to have a public discussion. So I'd exercise caution with that deletion.
Okay. Representative Bear?
Same comment.
I would go a third time on that, is when you're discussing potential litigation, potential legal action, executive session sometimes needed and is appropriate. Any further discussion on the amendment? Question being called. All those in favor, say aye.
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 Opposed?
No.
Amendment's not adopted. Okay, anything further on page 4? Okay, any further comments on the bill? All right, sensing you're ready, we'll take a roll call vote. Yeah, okay. We'll have a roll call vote on House Bill 141.
Representative Bear?
Aye.
Representative Burkhart?
Aye.
Vice Chairwoman Duncan? Aye. Representative Ayer?
Aye.
Representative Gray? Representative Heiner?
Aye.
Representative Sherwood?
No.
Representative Western? Chairman Greer?
Aye.
8-1.
Okay. Great. You guys, Representative Earlston, you'll be ready? Comes up, okay? Next item up for our consideration is House Bill 89, and co-sponsor Crago is going to present this bill for us in an amendment at the same time, right?
Yes, sir.
Okay, go ahead.
Thank you, Mr. Chairman, committee members. Barry Crago, House District 40, and I bring to you this morning House Bill 89, which relates to ad valorem tax enforcement. And really what this bill does is it's an effort to give the Oil and Gas Commission the ability to temporarily seal and shut in wells until unpaid taxes are paid. As you look at the original language, we had put a dollar amount in there and we had used the word plugged and we had set a time period of around 90 days. And once we had the bill drafted and had discussed it with the right people, the Oil and Gas Commission, and with industry, they had recommended we make some corrections, and that's contained within the amendment. I believe I sent one on all of your desks. And essentially what the amendment does is change the word plug to shut in and seal, which is more of a temporary fix, can be undone quickly once the taxes are paid. We took the dollar amount out, and I think, that was to direct, I guess, point us in the direction of, hey, it doesn't matter how much you owe. If it's not paid, it needs to be paid. And so whether you're a small producer, large producer, you have to pay your taxes the same. And so we took the dollar amount out. We then changed the 90 days to 120 days. And I believe the Department of Revenue might speak to that. I don't know as to why we needed to give a little bit more time period in there based on how their internal procedures work. And then the last thing we did is we added severance. So it doesn't just deal with ad valorem, it's actually gonna roll severance tax collection in there as well, because now, under the new system, the Department of Revenue is dealing with both of those at the same time. And so fixes that. And so the bottom part of the amendment, the amendment to 3914-208 deals with severance. And so that's why that little paragraph is also included on the amendment. Pretty simple. There's a difference. Last year we dealt with, in the last 3 years, we've dealt with liens and converting over to monthly payment. And the problem is there's a difference between a lien and enforcing a lien. And while you're trying to enforce the lien, it takes time. And often during that time period of enforcement, minerals are continuing to be pulled out of the ground and the taxes aren't being paid. This gives the state the ability to do something in that interim while we're trying to enforce the lien as well. That's about it, Mr. Chairman, and I'd gladly answer any questions the committee may have.
Representative Heiner.
Thank you, Mr. Chairman. Representative Crago, could you give us a definition of what it means to seal a well?
Mr. Chairman, Representative Heiner, actually the director from the commission is here today, and that'd be a great question for him. He could give you the exact technical definition, but essentially it's they actually put, I'm going to say it's like a sticker or seal over the well, and they're with their stamp on it, with the commission stamp, and it says you can't pull minerals from the ground while that stamp's on there until it's removed. Best way to explain it, but he'll give you a better definition, I'm sure.
Representative Air.
Thank you, Mr. Chairman. Representative Crago, could you give us some idea regarding the magnitude of the problem we're seeking to fix here?
Mr. Chairman, Representative Air, it would depend on the situation. I can tell you there are places, for example, in our county at home where we're talking about taxpayers who are in arrears millions and millions of dollars. And a lot of that, there are other situations where that may arise in the future. We can't predict the future. I don't necessarily know. There are places in our neighboring county to the east that they have the same problem. And so I know this is a fix that the Department of Revenue has wanted for a while. They have not had this ability, and it's one I think we've needed for a very long time. And whether it's $50,000 or $10 million, This gives them the ability to go, gives them the leverage to go get that tax collected without going through a long legal proceeding.
Representative Bear?
Thank you, Mr. Chairman. Representative Craigo, you and I had a discussion yesterday about individuals getting kind of caught up in a situation where they maybe were challenging the amount of taxes that they owe, and they would pay a portion, but not all of it while it was in a challenge situation. Appreciate your last answer as to the magnitude of the problem, but in an effort to avoid unintended consequences with a bill like this, is there a situation where someone could be challenging the taxes, not be paying a portion of them, and have their operation stopped?
Representative?
Mr. Chairman, I believe that's why we put the change in the dates in there to deal with the Department of Revenue's timeline on tax appeals, on ad valorem calculation, as well as severance calculation, is so that that appeal process, the time to appeal can go through.
Yep. Representative Burkhart?
Thank you, Mr. Chairman. Representative Craigo, is the intent here, and I just want to be clear, for a company that say has 10 wells in your area, 10 wells in the eastern part of the state, that the department shut in all of those wells or only the ones that are in arrears?
Mr. Chairman, Representative Burkhart, we're giving the discretion to the commission at this point. The language uses the word may, and so I think they could determine at that point at their level on how to best enforce that.
Representative Heiner?
Thank you, Mr. Chairman. Representative Craigo, some of these wells, if you shut them in, will never come back. They face irreparable harm. So if we shut some of these wells in that shouldn't be shut in, it not only harms the producer, but it harms the state as well through royalty payments and severance tax. Is there no other way to deal with tax issues than to cause irreparable harm by shutting in wells?
Good.
Mr. Chairman, Representative Heiner, so before this process takes place, the producer will actually have a hearing with the commission. And then they may convince the commission that it's not proper to shut that well in for the exact reason you just said. They may say, okay, if you need to shut some of our wells in, seal them, go seal these, but don't touch this well or this well because there will be the damage that you just said. And so there's going to be several processes in here that protect the producer from those kind of damages, I believe.
Representative Burkhart?
Thank you, Mr. Chairman. While we've talked a lot about shutting in the wells, there's two words here that just I need some clarification on. Prohibit drilling. Is that to prohibit the company from drilling any new wells, even in a different area of the state?
Mr. Chairman, Representative Burkhart, again, I believe that's going to be up to the discretion of the commission, and it's going to depend on probably the amount of money we're talking about, how many wells they're not paying taxes on versus how many they are paying taxes on.
Any other questions, committee? Okay, Representative, as a general rule, the oil and gas industry is good about paying their taxes, I would say. Is that a fair statement?
Mr. Chairman, very good about paying their taxes. And I think that's one of the things to policy-wise to realize the importance of this bill is 99% of our people are paying, our producers are paying their taxes, and there's a handful that are not. And why should they get to continue producing while not paying their taxes while their comrades are paying their taxes? They're doing their darndest to keep their taxes paid, and some producers are not. And this gives us a way to enforce that law.
So, and just Representative Craigo on that specific point, there are a couple of bad actors who continue to pull the resource out of the ground in Wyoming, receive money for it, but yet refuse to pay their ad valorem and severance taxes. Is that right?
That's correct, Mr. Chairman.
Okay, committee, any further questions? Okay, thank you.
Thank you,
Okay, who
committee.
wishes to testify on this? We'll have the Oil and Gas Conservation Commission come up.
Thank you, Mr. Chairman. My name is Tom Kropatch. I'm the Oil and Gas Supervisor for the Oil and Gas Commission. I don't have a lot of testimony to provide on the bill, but I would like to maybe provide some input on some of the questions that were asked of the previous Representative Crago. To define sealing, after an order from the commission, our staff would go out, usually in cooperation or in conjunction with the actual operator, their lease operator, and seal the well. So that's shut it in, whether that's just turning a valve on some wells to shut it in, whether it's de-energizing a pump, or whatever it may take, however they're operating the well, and so that it is shut in. And then we actually have a metallic seal. It goes either around a valve or maybe through a switch at an electrical panel, some way to have them not be able to turn it back on. And it has our information on there, and so they can contact us if they need to, if anybody else needs to that's out there. And think of it as essentially it's like an electrical zip tie that you'd see, a plastic little zip tie. It's just a piece of metal that clicks together so that it can't be removed without being cut. And then, the well would be shut in until they pay their taxes and we get a notice from the Department of Revenue that they've been paid. And then we could either work with the operator or just let them know that they can go ahead and cut that seal and bring the well back into operation. Maybe in conjunction with that of shutting in Representative Heiner's question on would that damage the well or could it damage some of the wells? There are some wells, especially the new horizontal well, that you probably would not want to shut in within the first 6 months or so of production in this scenario. So the commission at the hearing could take that into account and determine which wells are appropriate, or if there is a well that's appropriate to not seal in that scenario. And I think maybe in conjunction with a couple of questions from Representative Burkhardt and Representative Bear, the commission would have a hearing, so the operator would be able to provide their side of the story, so to speak. If they're in appeal of taxes or something, maybe the commission would say, well, once the appeal process is done, then we would order those shut in if you don't pay at that time, or there'd be options there on how they could work through a process with the operator at the hearing. And that's why that was included, I believe, after notice and hearing, so that the operator has an opportunity to provide the commission the details from their point of view on the tax.
Committee, Representative Duncan.
Thank you, Mr. Chairman. So what happens if we have someone who's really outlandish and go ahead and breaks the seal and continues? What happens in that case where you have someone who just blatantly ignores the process?
Mr. Chairman, Representative Duncan, in that case, there's other statutes within the commission's authority that allow the commission to do another hearing. They could issue fines. They could actually issue other penalties. We could have, for example, call on the sheriff's office if we need to have them come out and help us take care of the situation if they're violating a commission order.
Questions, committee? Any more? Supervisor, just one question. So you have this authority with respect to the conservation tax that you collect, is that correct?
That's correct, Mr. Chairman. We have the authority to enforce the conservation tax that operators pay to the commission, which funds the operation of our commission in addition to some other fees. And so what we see is most operators pay that, because if they don't, then we can call them in for a hearing for violation of the statute on the conservation tax and actually enforce that through payment, through fines, through sealing the wells if they need to. And what it seems to be is more of a deterrence to an operator. We still have some operators that don't pay the conservation tax, but not a significant number, and they don't get in arrears as far as they can with ad valorem or severance, because we can, when they don't pay for the first month or two, we'll send notices and then eventually have a hearing and get the problem taken care of. So it seems more of a deterrence than actual need for action in most cases, but there are some cases where we do take action on conservation tax.
So Supervisor, are there companies that pay their conservation tax but aren't paying their ad valorem tax because we don't have this bill yet?
Mr. Chairman, I believe there are, and maybe Department of Revenue has more information on those. I don't have because we're not involved in ad valorem taxes from the commission at this point, I don't have a great idea of which companies don't pay unless we get phone calls from the county, which we do when they get to be a significant dollar amount. But there are, most of those companies are paying our conservation tax, or all of them are, or otherwise we take an action.
Any further questions? Yeah, Representative Heiner?
Thank you, Mr. Chairman. Supervisor, are there other legal means to put a lien or freeze assets of these companies rather than shutting in production that ultimately affects the revenue of the state?
Mr. Chairman, Representative Heiner, I believe there are through Department of Revenue, and I think they could, and through the counties, and I believe they could provide more information on that than I can. The commission doesn't have that ability, but I think other organizations do.
Okay, any further questions? Okay, thank you, Supervisor, appreciate it. Department of Revenue, wish to?
Good morning, Mr. Chairman. I'm Craig Grenvick, the Administrator of the Mineral Tax Division for the Department of Revenue. Just a couple of statements here, kind of answering some of the questions from the committee. To start off, yes, our producers in oil and gas overwhelmingly pay the taxes that they owe. And in past years, one of our measures was what is the percentage of severance tax paid versus reported, and it's been well over 99%. With the downturn and through one of our bad actors out there, it dropped below 98%. So that is an issue. With one particular company deciding that their circumstances are such they felt they didn't have to pay until certain legal issues were resolved. On the other end of the spectrum, we do have only 4, I won't name any companies, but we really only have 4 out there who are far more minor in arrears and taxes. However, this has been an ongoing battle with them for years. A couple of them been under audit and still refused to pay. They didn't pay under protest, which they absolutely have the ability to do that. If we issue an assessment, all companies have the ability to pay it under protest. In those situations, obviously they're not in arrears. I mean, that's a legal battle, and we don't see how we could try to enforce it when they're taking the proper legal steps to resolve their situation. We've had scenarios where we have attempted to garnish the taxes through their purchasers. In the one instance, it worked for a couple of months and they just changed their purchasers. And the other instance that I know of, the purchaser refused to cooperate with us. So we were stuck there again, kind of a paperless or paper tiger. As far as the structure of this goes, we did speak with the Oil and Gas Commission and with Representative Crago and Representative of the Petroleum Association, and said 90 days straight out is a little too quick. After 90 days in arrears, we send out a notice every month of what their balance is. After 90 days, we will issue a lien with the Secretary of State's office. That isn't the all-encompassing problem-solving issue either, because some companies have ignored it and continue to produce even after that lien has been issued. But the structure of this is also protective for the industry, in that the department just can't go rogue and decide we have to work in conjunction with the Oil and Gas Commission, and they must have a hearing. And it was the department said, okay, maybe 120 days is probably a little more realistic. After they've already had a hearing, they've had an opportunity to be in front of the Oil and Gas Commission, they've had their opportunity to speak with us. And it seemed like a reasonable compromise, and I believe let the Petroleum Association speak for themselves. That was a compromise solution that we came up with. And that's really all the department has to say.
Representative Heiner?
Thank you, Mr. Chairman. So let me present a scenario. Sometimes the companies, production companies, have a discrepancy or they feel like some of the taxes imposed are not correct or improper, or there's some legal problems there. And so they put that money in escrow or decide not to pay until those legal issues are resolved. If this bill is passed, could the Oil and Gas Commission threaten them to shut them in unless they pay their taxes? And so the company decides to pay even though it's under protest, just so their production is not shut in. So could this be a heavy hand upon producers to force them to do things that they think are not proper?
Go ahead, Mr.
Mr. Chairman, Representative Heiner, I believe that would be an onerous abuse on the part of the department in those scenarios. Obviously, we're more than aware and have experience with appeals of the total amount due. And as I previously said, I believe they're not in arrears at that point. There is a legal precedent, a legal case out there for them to press that matter. And as a matter of fact, we can't waive interest unless there is a legal matter. So this is something that we deal with on occasion, more than an occasion, on these legal matters. And I do believe that a very solid legal argument by the producer could be made that, hey, we're paying this under protest. We're not in arrears. We have a legal claim here that you shouldn't be able to shut us in.
Okay, any further questions? Okay, Representative Bear, yeah.
Thank you, Mr. Chairman. Sir, I just want to know about this amendment here we're bringing. Says that the written notice will be given to the Oil and Gas Commission upon taxes being paid from your department. Written notice will be provided. What kind of time frame are we looking at from the moment you guys are paid up to date till we could see this well being brought back up into production? How does that
Go ahead,
process-
Mr. Chairman,
Yeah,
Representative Bear, obviously that onus is upon us. And any abuse on the part of the department will be noticed, and it will be mentioned to the proper authorities.
Go ahead.
I wasn't impugning abuse. I just was curious, what is the, what would that process look like and what would be the normal time frame? I'm just curious to know that.
There may be, we can ask Supervisor Kropatch that, which, their metal bands are sealed, so as soon as the notice is given, the operator can go break them. Yeah, so it could be instant.
I got that. I was just
Yeah.
wondering about the letter. We gotta have written notice from one department to another.
Oh, how long would it take?
Could it be via
How long would it take
electronic?
the Department of Revenue to
Right, could
get
it
the
be
notice out?
electronic? Could it be expedited? That type of thing.
Okay.
Mr. Chairman, Representative Bear, absolutely. The onus at that point becomes upon us to give immediate notice, and we can follow up an email with an absolute actual letter as well. We communicate at least weekly with the Oil and Gas Commission.
Okay, yeah, I wasn't understanding your question, so we got it. Good. Okay, any further questions? Okay, thank you. We appreciate it. Who else wishes to testify on this bill? So we'll go with Commissioner Novotny and then Mr. Obermueller after that.
Good morning, Mr. Chairman and members of the committee. My name is Bill Novotny, Johnson County Commissioner. I'm also here on behalf of the Wyoming County Commissioners Association. If you had the opportunity to meet with your commissioners last night and receive our bill review sheet, you will notice that this is a bill that the Commissioners Association strongly supports. This is not a Johnson County specific issue. However, at this point, it appears to be a one company issue. This company operates in 3 counties. It owes my county in excess of $30 million. It also owes a large sum of money to Campbell County and to a smaller amount to Sheridan County. This company has continued to operate. They've also actually continued to acquire assets in the state of Wyoming. So this problem is going to only continue to fester. What we are asking this committee to do is to give parity to the counties. The state already has this authority. This particular company became $5 million in on payment to the state on their severance. They were scheduled for a hearing to be shut down, and miraculously, they showed up with their checkbook and they paid their back taxes to the state. My county has worked for years to try to collect these dollars. We're exhausting all of our legal remedies. We've expended hundreds of thousands of dollars in legal fees. We've filed all of our liens. We've done everything under the law that we can possibly do. But this company continues to produce a asset that is non-renewable and is not paying their taxes. I would just ask, and we went to the Oil and Gas Conservation Commission and asked them if they could please shut them down. And what the Oil and Gas Conservation Commission told me was that they could potentially pass an emergency rule. They said that I needed to go visit with the governor about it, and so I did. And the governor said that he would prefer a legislative fix to this, which is really what you're seeing before. And I really thank the good chairman for his work and his work with Representative Crego on this. We are not anti-oil and gas. I would remind you also that 70% of the money that is owed to my county belongs to the school districts. A large portion of it also belongs to my special districts. So by them failing to pay, you're impacting my hospital district, my ambulance, my fire district, every facet of the services that we do. So I know there's some consternation that maybe this is a heavy hand, but really what you're doing is giving the commission the parity so that when we get in a situation where we're dealing with a bad actor, we can go to them and seek resolution. And we love the companies that work in our county and employ my constituents. But this really is a tool that we need as we deal with companies that choose to not honor their obligations and pay their taxes. So with that, Mr. Chair, I'd stand for any questions.
Any questions, committee? Okay, go ahead, Representative Duncan.
Thank you, Mr. Chairman. Commissioner Novotny, does this, help me if I'm way off base, but does this also help those that may quickly try and claim bankruptcy and to really skirt trying to pay their obligations?
Mr. Chairman, Representative Duncan, I really believe possibly it could. In the company that we're dealing with and the different shells that it had transferred hundreds, or not hundreds of millions, but several $1 million right before a bankruptcy that they filed. So really it would, I believe, help us combat those situations.
Okay. Any further questions, committee? Okay, thank you, Commissioner. Appreciate it. Mr. Overmuller?
Good morning, Mr. Chairman, members of the committee, Pete Obermuller, Petroleum Association of Wyoming. Been feeling neglected by this committee this session, so happy to be here oddly for my first time.
We can fix that.
Yeah, I know you can. Mr. Chairman, appreciate your work on this bill. Appreciate Representative Crego's work on this bill. I think you all know that as written, my organization opposed it in large part because probably the largest part was the plugging part, which gets to Representative Heiner's point, is that I think the goal in these situations is not to end the ability for the resource to be extracted. The goal is to have operators who meet their obligations, who are upstanding corporate partners to the state of Wyoming, and who can produce the resource and pay their taxes. So we all, Mr. Chairman, we all stand on the shoulders of people who came before us. I've been told by longtime members of the Petroleum Association that my predecessor's predecessor had a rule that came to be known as the Robitaille Rule, which simply, for this committee's purposes, was simply pay your darn taxes. That's all. And I'm very happy to maintain that rule. I think the amendment accomplishes the goal, Mr. Chairman, of trying to do this, and I really appreciate this hearing is hard because we've heard a lot about bad actors, about not paying taxes, about the impacts to Commissioner Novotny's county and all of that, and I appreciate the repeated reminder that it's very, very rare And in the case of severance and ad valorem, that really is, usually upwards of 99%. And so it's an isolated case. So a couple of things, Mr. Chairman, with respect to the amendment and moving it to the hearing at the Oil and Gas Commission, and also the timing. First, on the timing, Mr. Chairman, 120 days. Mr. Chairman, I think we would prefer 180 days, to be honest. There are, Mr. Gramick didn't talk about it, but there are actual sort of legitimate reasons, human error and otherwise, that make it take a little bit longer to work it all out than you might assume. Even, Mr. Chairman, there's instances where people accidentally pay a tax to a different tax district, or it gets credited by the department to a different tax district, and those sorts of things need to be corrected and take time to correct. And so there's that time frame in there allows for some of those unintentional errors to take place. I will say that, of course, when the commission issues a notice for a hearing, that's at a minimum of 45-day waiting period, or 60-day. Supervisor Kropatch can correct me on that. So there is a little time lag in there. I think we would prefer 120 days, but it's a policy choice for this committee. With that extension of time, we did feel that it was fair to drop the amount of the 2 million threshold down essentially to zero. That it really doesn't matter whether you owe $1 or you owe $30 million. Pay your darn taxes. If you've never been, Mr. Chairman, and I actually would invite the committee at some point to come to Oil and Gas Conservation Commission meeting on the second Tuesday of the month and watch their show cause hearings when something goes sideways. They are diligent. They are tough if the rules are not being followed, and they're also fair in helping companies meet their obligations in a way that allows production to continue. So we're pretty comfortable with that process, and the amendment matches authority that they already have, and we feel like they will be tough but fair at the commission. So, Mr. Chairman, I will leave it at that, and happy to answer any questions for you.
I'll go with, let me go with Representative Bear, Ayer, and then Lester.
Thank you, Mr. Chairman. Thank you for being here, Mr. Obermueller. Just a top-level question. You said you guys were opposed to the bill, but with an amendment to the amendment of 180 days, would you be in favor of the bill at that point then?
Mr. Chairman, Representative Bear. So every association has a process. We'll be meeting this afternoon to talk about it. I think it's highly likely we will move from the opposed to the support column. But I can't say that for certain until then, but I will send out a note as soon as my members tell me the direction.
Representative Bear.
Thank you, Mr. Chairman. Mr. Obermueller, I have a question on the timing here. The commission can take this action of sealing and shutting in a well when the taxes are 120 days delinquent, but only after notice and hearing. So that notice and hearing will take place during that 120 days?
Mr. Chairman. Representative Aaron, no, that's not correct. There's the 120-day minimum under the bill, and then after that is when the Department of Revenue will give written notice to the WOGCC about the delinquency, and at that point, the OGCC will issue, will look at the facts and then can order a notice of hearing, and then there's a delay there after the notice. So even if it happened right at 120 days and Supervisor Kropatch issued a notice that day, there'd be an additional minimum of 45 days, possibly 60, before the hearing would even happen. So there's quite a time frame there. And keep in mind, if I might, Mr. Chairman, that's all under the new regime of monthly payments too. So starting in March of this year, if an operator misses a March payment, and then misses April or May or whatever, that clock starts ticking on a monthly basis instead of in a biannual basis as it was before.
Thank you.
Representative West.
Thank you, Mr. Chairman. Mr. Obermueller, you want to extend the 120 to, I think you said 180? And one of the reasons you cited was a clerical error by one of the clerks, commission, et cetera. I would think that 120 days is probably plenty of time to remedy that kind of clerical error. And that the only way it goes that long is if there's someone who has more or less made a deliberate decision to forego paying these taxes. Thoughts?
Mr. Chairman, would you agree?
Would you agree?
Appreciate that, Representative Western. Yeah, perhaps. It's a little bit difficult to know, and I think part of it for me is comparing it to where the state would have been previously under all of this, where there was 180 days is significantly faster than it was before, significantly. And I adding that additional 60 days to ensure that various unintentional well-meaning mistakes can be corrected to not have the unintended impacts that some of the others have mentioned is reasonable. But again, it's a policy choice. On simply telling you what I think I would prefer, but it's your choice, Mr. Chairman.
Follow up?
Thank you, Mr. Chairman. Mr. Obermueller, in the instance of these bad apples, from the time they go into arrears to the time they file for bankruptcy, shed all that debt and those obligations, come out as a new company, but retain these assets. I know you're not a bankruptcy attorney, but do you know how long that process generally is?
Mr. Chairman, I couldn't give you a timeline on that, but your question does raise a point that I think I want to just make sure that you all are aware of to Representative Duncan's questions, and you're bringing up bankruptcy. I'd encourage the committee to think about these. These are two separate things. This enforcement would happen likely pre-bankruptcy. And to Supervisor Kroprach's point, a bit of deterrent. The point of this is to try to not get to the level of arrears that Johnson County has realized. At a level that much, this bill might force bankruptcy. But then that goes into the lien process that you all have done a couple years ago, and the legitimate legal process of bankruptcy. Bankruptcy by itself does not make you a bad actor. It's a legitimate legal way to deal with financial ramifications, and there are processes for dealing with that. This is to try to deter from getting to the point where we see ourselves with at least one company. So I know that's not answering your question, but at previous discussion, I think we kind of separate bankruptcy from non-bankrupt, non-tax-paying companies, which is important.
I think those are good comments. So the whole concept here is deter, catch it early, don't let it happen. So, Representative Bear.
Thank you, Mr. Chairman. Just to follow up to what Representative Western was saying with the difference between the 120 and 180 days. And I think you mentioned, Mr. Obermueller, that a good actor could accidentally send their payment to the wrong division. And there would be a certain amount of time to get that money back. If it were a cash flow issue for that company, that could create even a greater cash flow issue where this additional 60 days could make a difference. Wouldn't you agree?
Mr. Chairman, I would agree.
Yep. Committee, any further questions? Okay.
Thank you, Mr. Chairman. Mr. Obermueller, when we switched to the monthly, so I was just calculating the 120 versus 180. So we're looking at, by the time you have the 180 days that you're suggesting, plus 45 days for the hearing. So we're looking at 225 days, which ends up being 7.5 months in the rears. So can you help me with how does that work with the monthly payments? How much further are we pushing them back to be more in the hole than we are I'm not quite sure where I'm going with this, but I'm just trying to wrap my head around, because we used to do it in the, you know, a bulk payment versus monthly. So is this still a better process because they're not going to be as far in the rears because they're only 7.5 months behind?
Mr. Chairman.
Did I make any
I think I
sense
follow
to you?
Representative Duncan.
Sorry.
Yeah, I mean, I think it's just, look, again, it's we have some comparisons, right? I mean, first of all, we know from Supervisor Kropatch that this authority hasn't existed at all before. So 7 months is better than infinity, number one. Number two, under the old system, you weren't delinquent until, you remember it was you pay your first half in September and second half, blah, blah, blah. If you missed that first half payment, you weren't delinquent. You had the right to not pay that and then pay it all in December. So that's already 12 months past production before there's ever an inkling that you're not going to pay. So at a minimum, it's 12 months. Maybe this is 7.5. I do not have to do the math on it. I think eventually it'll probably end up being that much anyway for OGCC to get it on their docket and make it happen and all of that. So again, it is certainly better than it was. It's authority that hasn't been there before. I regret that we even need to have this discussion. I wish it weren't the case, but here we are.
Yep. Any further questions? Okay. I do have one question in terms of if a company were to pay their taxes, ad valorem taxes to the wrong county, for example, that could happen very easily. And if they were found to be delinquent, and if they went in front of the commission, wouldn't they be able to bring in evidence that they paid all their taxes, and then the commission could correct that before any action was taken?
Mr. Chairman, that's true.
No. Okay. All right. Mr. Wheeler, thank you. We
Thank you.
appreciate your testimony. Anybody else wishes to testify on this? Ms. Anderson? Why not?
Thank you, Mr. Chairman. Shannon Anderson on behalf of Powder River Basin Resource Council. At the risk of losing votes for this bill, I am in favor of it. We do.
Hold on. That's twice this year.
And we just wanted to, I think, bring in a point that hasn't been raised yet, and that is these same companies that owe the state money and owe counties money often owe private parties money as well. So it would help enforcement of things like surface use damage payments and mineral royalty payments, federal mineral royalties owed to the federal government. So we do believe this bill is a great one, both for the counties and the state, but also helping private landowners with these issues that they face with these companies as well. So just wanted to bring that up. Thank you.
Okay, thank you. Representative Western.
Thank you, Mr. Chairman. Ms. Anderson, I know you've paid a lot of attention to bankruptcy proceedings and the process. As the Vice Chair pointed out, we're looking at, if we extend this back to 180 days, we're looking at about a 7.5-month process from the date of being in arrears, the type that there's any kind of adjudication on this case from the commission. My question is this: how long does it take for some of these companies to go into bankruptcy, prep the paperwork, do the filings, when bankruptcy rules become effective? How long does that take?
Yeah, Mr. Chairman, Representative Western, it really depends. Every bankruptcy case is different. Some do go on for years. Black Jewel, for instance, is still going on, not related to the mines here in Wyoming, but still very much related to the mines in Appalachia. So it does take some time. I would note, I would just highlight, I think, what was previously mentioned. Actually, the company that we've sort of been alluding to earlier is not in bankruptcy. And they are very much still operating. They have thousands of wells in the Powder River Basin. They have an office in Sheridan that I drive by regularly. They have property and assets that could be dealt with, I think, in a different way if this bill was in place. So I think, again, the goal is to keep companies, to deter them before bankruptcy happens, to give some additional enforcement tools on our taxes, and to make sure that, the state's getting paid what it's owed. But yeah, bankruptcy is not a simple process. It's not, there's not a time frame that I can say. I mean, it really is company by company specific, depending on how big the company is, how many assets they have, how many claims, what that claim process looks like, any number of factors.
Okay, any further questions? All right, thank you. Anyone else wishes to testify? Yep, please come forward.
Mr. Chairman, Brenda Henson, Director of the Department of Revenue. I thought perhaps if we went back and looked at our new timetable, that would be beneficial. And so I thought I'd give an example of January 2022 production. So for January 2022 production, should the bill that's progressing to clarify the timelines for the monthly ad valorem be successful, and how we've rolled this out, January 22 production is reported no later than March 25th of 2022. We then determine an estimated tax amount based on last year's mill levy. We send out an invoice by April 10th. That tax then becomes due by April 25th. So with the language in this bill, you've got 120 days. So we would not notify of delinquent taxes until August 25th is the first time that we would notify that they're 120 days delinquent. And then when you add the 45 days for a hearing, you're looking at the middle of October. So even with the 120-day language, I feel that there's significant time for us to do our process for Oil and Gas Commission to accomplish the scheduling of a hearing and gathering of information. And I think the monthly ad valorem changes this significantly. If we were under the old statutes, then I think it would be a different discussion, but certainly, hopefully, between monthly ad valorem collection, and again, the entity, we're collecting everything now, so you're not going to see where a taxpayer is paying a county directly. They'll be paying, starting this month, all of their mineral taxes, both severance and ad valorem, to the Department of Revenue. So we shouldn't have that confusion. So with that, Mr. Chairman, I'd stand for any questions.
Yeah, committee, any questions? Thank you, we appreciate
Thank
that.
you.
All right, anyone else wishes to testify? Okay, with that, we will close public testimony. It's the committee's pleasure.
Move the bill.
Moved by Duncan, seconded by Air. Okay. Yep, Representative Western.
Okay. Move the amendment as well.
Okay. Is there a second? Seconded by Duncan. Okay, discussion on the amendment. Okay, Representative Bear.
I'd like to make an amendment to the amendment and strike 120 days and change that to 180 days.
Okay. Seconded by Heiner. Any discussion on the 180 versus 120? I think we've had pretty good testimony on it, but go ahead, Representative Bear.
Yeah, I would resist the amendment. I think 120 days is plenty when you consider the 45 days for notice and hearing on top of that. And then as we heard from Ms. Hanson, how long it is before they actually become in arrears in relation to when the production took place. And if they had a clerical error or some unintended mistake, certainly the commission would determine that at their hearing and be able to correct that before they took any action. So I think 120 days is plenty.
Representative Duncan.
Thank you, Mr. Chairman. And I agree. When you add it up, currently at the 120, they go all the way to October. If we do 180, that means that's a whole year. That it's back into January again. So I was leaning towards 180, but now after the clarification, I'm back to the 120.
Yep, Representative Heiner.
Thank you, Mr. Chairman. I think we've heard in testimony here today that that 99+% of the producers are doing well. They're paying their taxes. This legislation is targeted to that less than 1%. Those very few that are having problems like this. So most of the producers are doing well, and I don't want to have some kind of a clerical error or something like COVID that all of a sudden sprang upon all the companies and businesses, create a situation where we're shutting in production and being punitive on some of these producers that are doing well and trying to fulfill their obligations to pay taxes. Another 60 days, for this less than 1%, I don't think it would hurt, because we don't want to create a obstacle for those that are trying to do their best.
Mr. Chairman?
Okay, yeah, let's go with Representative Sherwood, and then we'll go.
Thank you. Yeah, I'm feeling the same way as Representative Duncan in terms of was leaning towards the 180, but then after the complete testimony, in favor of keeping that at 120. And a saying that my mother often uses is, you give them an inch, they take a mile. And when we're dealing with, bad apples, I think that we should nip that in the butt as soon as possible. Thank you, Mr. Chairman.
Yep. Representative Western.
Thank you, Mr. Chairman. Maybe I just wasn't listening properly, but I don't think the concern here is this is a tool to ensure that the state, the counties collect their taxes before the bankruptcy option comes around, to prevent that from happening, or at least so that they can get their money before we enter that phase of this kind of issue. I personally did not get any resolution of whether 120, 180, or whatever day would help avoid these kind of instances moving into bankruptcy. So that's kind of my concern. I'm totally fine with 180, so long as this doesn't give these companies the time they need to go into bankruptcy and shed these obligations.
Okay. So any other comments on the amendment to the amendment? Representative Air.
I don't think we're penalizing the 99% that pay their taxes on time. This 180 days has no impact on them, or 120 days. So the good 99% of the producers who follow the rules, pay their taxes, this won't have any adverse impact at all on them.
Any other comments? Okay, so 120, 180, it's better than what we've got, okay? Hands down. Just the concern is, and this testimony wasn't here, but the Oil and Gas Conservation Commission will have a hearing in 45 days, okay? They'll bring someone into that hearing and they may say, you will do this, this, and this by a certain date, which is what they often do, is they give people a chance to rectify the situation. So now you got another 30 to 60 days going by before they really have to come in and then take and use the hammer. And so, and I would encourage every member of this committee to go to one of those hearings, take your glasses, because their docket's very hard to read. But that's their mode of operation, is they typically bring people in and give them at least one chance to correct it. So I'm not going to vote for the change to 180, but I'm just going to say either way, 180 or 120, we're moving in the right direction. So any further discussion on the amendment to the amendment?
Thank you, Mr. Chairman. I think you bring up a great point with the 30 to 60 day, whatever the commission does there, but we don't have that in this amendment. It would eventually be in statute. I do believe that the commission, I've heard testimony, I believe you, that they do give the opportunity for the producer. They certainly are even-handed. We saw that from many testimonies today, but we're not putting that into statute as we operate here. So I would again say that I think we should give that opportunity for time, because that 30 or 60 days that the Oil and Gas Commission may afford is not specified in this amendment. Thank you.
Okay, so I agree with you. It's not in statute. Their rules aren't in statute. Their procedure on how they operate isn't in statute. So their goal is to conserve the resource and to make sure that the resource is properly accounted for and that the taxes are paid back to the state. So, okay, good enough.
Question.
All right, question on the amendment to the amendment. So 180 days versus 120. Let's just go ahead. All those in favor, raise your hand. 1, 2, 3. All those opposed? 1, 2, 3, 4, 5, 6. Okay, that amendment to the amendment's not adopted. Back on the amendment. Any further discussion? Question being called. Oh, go ahead, Representative Burr.
Just want to make a comment. I voted against this bill on introduction because I had these very concerns. And I'm so glad that this amendment was brought because it has alleviated the concerns even with 120 days versus 180 days. And I would, again, just repeat the good chairman's comments that this is better with the way we've got it now than what we have in the past. Thank you.
Question.
Okay, question on the amendment. All those in favor say aye.
Aye.
Okay, just try that again. All those in favor of the amendment, say aye.
Aye.
Go. Opposed? Very good. I don't think there's any reason to work the bill because the amendment is the bill. Roll call vote on House Bill 89.
Representative Bear,
Aye.
Representative Burkhart.
Aye.
Vice Chairwoman Duncan.
Aye.
Representative Ayer,
Aye.
Representative Gray. Representative Heiner. Representative Sherwood,
Aye.
Representative Western. Chairman Greer.
Aye.
8 ayes, 1 no.
Okay, thank you. Next bill for our consideration is House Bill 123. And the good speaker got to watch our great committee work the issues and debate them.
Gotcha.
And I'm sure you're
Okay.
very impressed. Right?
Good morning, Mr. Chairman, members of the committee. I am very impressed. Thank you for your good work.
You take it.
As you know, I'll just make a comment to the last bill. That's actually an issue that I've been following for my entire legislative tenure. The ad valorem issue, because my county is one of those counties that's still dealing with this issue. So I thank you for your continued work. Madam Vice Chair, this morning I bring you House Bill 123. House Bill 123, I think I can describe it as a continuation of a previous bill, which was House Bill 129, which was enacted 2 years ago during the 2020 budget session. If you'll recall, that bill allowed the disposal of wind turbine blades into coal mines as backfill material. So that process continues, and I think there's members of there's a representative from the Department of Environmental Quality, Wyoming Department of Quality, here to speak about where they are in that process. This most recent bill, House Bill 123, was brought to me as a constituent request, as a community constituent request of a company that is interested in disposing of materials in a manner that is not being done in the state of Wyoming for two reasons. One, it's an economic thing for them. It's a business enterprise that they want to undertake. Two, they see it as a way to actually reduce the pressure on our public landfills, the landfills that are taking the materials. The specific material that these folks are interested in disposing of in a different manner are tires, vehicle tires, which, as you would imagine, takes up a lot of space in a landfill where we'd rather keep our household refuse and other materials in, and we, as a state and as communities, spend a lot of money putting those landfills in place. So this bill is, like I said, I think reasonably can be seen as an extension of the original bill, which was very specific to both the type of material and the type of mine that it was applicable. This broadens it in two ways. One, it has a definition of an inert material, a material that will not degrade, et cetera, and damage groundwater, et cetera, groundwater, land quality, et cetera. The other thing is, so there could be lots of different, the other one is this goes to non-coal mines. And particularly of interest in, for at least in my mind, when these folks brought this to me and say, hey, what can we do? And I said, you know what, there's a really ideal kind of mine out there that we have very few, particularly in Northeast Wyoming, some in the Bighorn Basin and likely elsewhere. It's bentonite mines. Bentonite mines, they almost naturally seal. That's part of what, the characteristics of bentonite is. I'm not saying that there aren't other mines that may not be types of mines that may not be also usable after determination by the company and verification through the Department of Environmental Quality. But so that's what this is about.
Certainly if I would make, and I can walk quickly through the bill, inert materials. I think when we talk about rubber tires, there are reusable and recyclable processes, but at this time, they're not economically viable. And so there may be an interest, if the committee so chose, and to insert on line 6 after not, something about economics, economically reusable or recyclable. And that way, there's whether it's transportation costs to get it to a place where it could be used or reprocessed or whatever, we have something there. Because certainly rubber can be reused or recycled. Just, is there a market? Is there a viable way to do it here in Wyoming? Mr. Chairman. Mr. Chairman?
Let me interrupt you just on that point, because that definition was one we needed to look at. Just from a structure standpoint, regarding being economic to recycle or reuse, means a material that it is not economical to reuse or recycle. Is that, I'm trying to look at structure and maybe have you think about that as we go to work the bill.
Mr. Chairman, I think economically or economic too, I think either one is fine. And maybe it's actually a qualifier in another sentence, talking about, there should be some review of the economics of whether it's recyclable or not. So it may be in that sentence, or it may be something you want to add later. And Mr. Chairman, if this makes it to the floor, as you know, we're pressing against committee of the whole and the committee of the whole. If this makes it to the floor, I'll continue to work with the committee if they should move it forward. But I do think that's something that we have to keep in mind. So, thank you, Mr. Chairman. I'm walking, and I'll try to walk quickly through the bill because I know time is getting short for you. 3511-402, which is the bottom half of page 2. This is where the wind turbine, line 19, the wind turbine came in. And then the top of page 3. So when we put this bill together, as you know, for the wind turbine blade, we had a 25% basically revenue capture to help administer the program through the Department of Environmental Quality, so that the users of this would be funding the positions or the needs, the regulatory needs of that agency. Well, and the agency will talk about this. That application is before OSM. I think OSM is the right place. OSM right now. So it's not in our interest to change the terms by which we're have that application forward. So I'm going to ask the committee to actually delete the 19, page 219 through the remainder of the page, and the page 3 lines 1 through 10. So we'll take out the entirety of the previous bill, House Bill 129 from 2020. We'll just take out that piece. And the only thing we were changing there was the 25% to 10%. The 10%, thank you, Mr. Chairman.
While we're on that point, go ahead, Representative Burkhart.
Thank you, Mr. Chairman. Speaker, if you delete on page 3, line 2 through 9, then you also delete that 10%. And I thought the intent is to lower that for these materials in non-coal mines. Is that your intent to now delete out all of that payment?
Mr. Chairman.
Go ahead.
So, Mr. Chairman, the top lines on page 3 are to the wind turbines.
Okay.
And when we get to the bottom of that page, I'm sorry, on page 4 is when the 10% comes in for the new materials, inert materials. All I want to do is not complicate, Mr. Chairman. All I'm doing by removing this is not complicate the process that our executive branch, the Department of Quality, is already taking place, already in progress with the coal mines. This will be for non-coal mines. So I'm trying to remove that. I don't want to get in the way of what they're already doing. It's basically what it is. And when I talked to one of my Senate co-sponsors, who also the Senate co-sponsor on the other side, he said, yeah, I'm fine dropping it until we understood we would complicate this for the process that's already ongoing. So that's why it'd be my suggestion we take it out. So then all that remains essentially is all new language for this new opportunity. And the new opportunity essentially mirrors what was done in the coal mine language. If you look back at House Bill 129, which became House Enrolled Act 68, we have, and I'll just go down on page 3, Romanet 15, we have this, same thing, except instead of wind turbine blades and towers, it says inert materials and backfill non-coal mining sites. And then you get to the next one is minimum depths, same as the previous bill. And then you get to incorporation, removal of the mechanical materials, which is this, similar. And then disposal fees, and that's where the 10% comes in. And then the incorporation of the amendment. So actually the bill is identical with 2 changes. 3 changes. Inert materials, so it's broader than the wind turbine. It's non-coal mines instead of coal mines, and it's 10% instead of 25%. The rest of the bill was my intention to make it identical to what we passed in 2020. Mr. Chairman, I stand for any questions.
Any questions for the speaker? Representative Bear.
Thank you, Mr. Chairman. Mr. Speaker, this may be a technical question that we need to ask somebody else, but most tires nowadays have steel belts in them. Is that included in the inert material? Just a quick technical question.
Mr. Chairman, so I am not I appreciate that. And when I posed that question to the proponent of this potential opportunity, they actually made the case that there's a way to separate them or some process, but I don't know that. I know when we talked about it, they've already actually ordered the machine, portable machine. They can move around the state of Wyoming. It's $1 million investment to undertake this. But unfortunately, the representative from that company, Mr. Lundvall, couldn't be here today, and we don't have, anyway, couldn't be here today. They will be here before, if it gets further in the process, they will be here, and I will try to get that answer to that question in a tangible form, in a written form for you, for the committee and for the body so when I do present on the floor, I can respond to that to the body. Thank you, Mr. Chairman.
Representative Heiner.
Thank you, Mr. Chairman. Mr. Speaker, MSHA not only inspects mines, coal mines, trona mines, all these different kind of mines, but they also inspect gravel pits that falls within their purview. So as we open this up to non-coal mines, could this open up gravel pits for these inert materials to be disposed of as well, as it may be classified as a mine?
Mr. Chairman, I believe it could. I think it would have to do with the characteristics of the mine and whether whether there's water involved, whether there's groundwater involved, et cetera, because part of it's not just the materials, but you also have to look at the location, whether you have contamination or et cetera. Now, maybe that we need to be more specific in the bill, but it certainly is a backfill material. It's not to be something that actually alters the physical environment or the environment. So I would say generally, just in my limited experience, gravel pits are generally in alluvial places where there's deposits of materials. That means there's probably water, there's other things there, and that would not be an ideal place. The ideal places are the places where there's, very little, or almost no interaction, bentonite mines, et cetera. So I think our department and the proponents would want to minimize their environmental liabilities and stay away from things such as maybe pits that do not have those characteristics. But it certainly is possible. There are non-coal mines. Yes, Mr. Chairman.
Yep. Follow up.
Oh, thank you, Mr. Chairman. Mr. Speaker, so if someone decides that they want to dispose inert materials within a gravel pit before closing, would they have to get any special permission from the DEQ, or with this bill, could they just go ahead and do that without evaluating the water or any carrying capacity of the alluvial fan?
Mr. Chairman, my understanding is the establishment of the standards, that there will be the rules permitting all those things would come through both from the council to the DEQ, and the DEQ would enforce those, Mr. Chairman. And I think that's 3511-402, even though we struck the part from the coal mines, keeping that same standard for these non-coal mines. So they would go through a rulemaking process to take into account all those things. Thank you, Mr. Chairman.
Okay, any further questions for the speaker? Okay, if you hang around, we appreciate it.
I think we should.
So,
Thank you, Mr. Chairman.
Mr. Ash, I assume you're the sacrificial lamb, and even though administrator of the Industrial Siting Council, this is your old playground, right? Yeah. You and I've spent a lot of years talking about garbage.
Mr. Chairman, members of the committee, my name is Luke Esch. I'm the Deputy Director. With me today is Suzanne Engels. She is the Administrator of the Solid and Hazardous Waste Division. Director Parfit and Administrator Wentland could not make it here today, so we are the sacrificial lambs. We know you're under a time crunch, so we'll make this brief. The department, we have a few comments and some suggested changes for this bill. Our primary concern relates to the broad nature of inert material. As the good speaker indicated, that the definition talks about reuse or not reusable or recyclable. There's a lot of materials that would fall within that, including tires, as well as cardboard, rock, all that can be reused in some manner. The addition of economically recyclable would not exactly clear it up for the department. In whose determination would it be economically recyclable? And so I think there'd be some questions along with that. In addition, the undergo any significant physical, chemical, or biological transformation. That word significant leads a lot of uncertainty involved up to the department. So I guess our recommendation would be, if this is geared towards one particular type of material, and that chipped tires, that be our suggestion that you be specific and say chipped tires to backfill bentonite mining sites. That would allow the department to go down the path of doing the rulemaking for one particular type of material, and to see if we wanted to branch out later, we could broaden that. But we really feel like if it is narrowed to one type of material, that would allow it to move forward without as much concern on the department's behalf. The speaker also indicated that the modification of the 25% for the wind turbine blades to 10% would have some ramifications for our submittal to the OSM. We did rulemaking last year, submitted our rule package to OSM for approval. That is still pending. If this change were to move forward, we would have to put an amendment in, which could slow that OSM approval further. So we would recommend, we agree with speaker to not make that change. One additional modification we would suggest is in 2020, 2 years ago with the wind turbine blade, there was a modification to 3511-103 D2G, which removed the wind turbine blade placement in coal mines as a part of the reclamation from the definition of a solid waste facility. So that removed it from the jurisdiction of the solid and hazardous waste, which prevented it from having dual permitting. So we would also recommend that modification as well. And with that, and I knowing you are on a time crunch, we will stand for questions.
Yeah, go ahead, Representative Duncan.
Thank you, Mr. Chairman. Help me with the rulemaking part. Can we leave it the way it is with the inert material, but then when it comes to the rulemaking, can you be specific as projects come to you? Or, I mean, is that an option?
Mr. Chairman, Representative Duncan, it is an option, but whenever you have broad statutory language, the rulemaking can go any which direction. So it's always assumed that the legislature intended what they wrote. And so if we tried to make a rule that said it's just chipped tires, and we would have significant comment from everybody saying, well, they could have said that, and they said inert material. So that, I guess, would be my response.
So to follow up on Representative Duncan's question, if we went with, I understand the reason to say just tires. In 3 years down the road, there's another material that we feel would be appropriate. Be pretty easy to bring that in at that point to a new set of rulemaking. Am I correct in that statement?
Mr. Chairman, I believe so.
Okay.
Mr. Chairman.
Yep, go ahead.
A question to you, that would require us to go back in and change the statute to broaden it again though, correct?
Yes. But that's what we do.
Yeah.
Yeah, I'm glad you brought that up, Mr. Esch, regarding the permitting. And I'll have to look at that to make sure, so we don't have to have dual permitting for a hazard or for a solid waste site. And that was 3511-103E, Romanet 2G. Was that the site?
Mr. Chairman, it was 3511-103D.
D?
D is in dog.
Okay.
2G. And then that you would just modify that to create or to include the newly created 402A15.
Okay. Okay. We're not probably gonna do that with a standing committee amendment, but we can, okay. Okay, any further questions for Mr. Esch? Okay, thank you. Anyone else wishes to testify on this? Mr. D-Type?
Thank you, Mr. Chairman, members of the committee, Travis Deti with the Wyoming Mining Association, in support of the bill. And I think Speaker Barlow kind of laid out, where this is coming from. It's an opportunity for a company to take these materials, the chip tires in this case, generate a little revenue and get a little revenue for the state. So we support the concept. Appreciate the speaker's concerns and noting about the wind turbine process right now. And that was the one thing we had concerns about. And basically just, we want to get that program up and running. We are getting company inquiries for the wind turbine disposal. We want to get it up and running, and so we appreciate that. Whatever you guys can do to work the definition to make it workable, we support the concept in the bill.
Yep. Any questions for Mr. D-Type? All right, thank you. Anyone
Thank you,
else
Mr. Chairman.
wishes to testify? Okay. Anyone else? Mr. Speaker, did you have something more you want to say? We will give you great deference, sir.
Thank you. So, Mr. Chairman, I do appreciate the comments, and certainly one of the reasons I went with a broader term, inert, was if you look at Title 35, which I spent a lot of time in on my time in Labor Health Committee, every year or two we add another something to it. It's not the end of the world, I agree. So if this committee wanted to be more specific, limited to chipped rubber materials or tire materials, or however you want to do it with this current definition, and then we just add to it, or as maybe other materials come forth. The other way is that maybe there isn't rulemaking until someone actually makes an application based on a certain type of material. So then we leave the statute broad, and then it's based on application, suitability, and they come in. So, Mr. Chairman, I'm not suggesting one way or the other. I'd be glad if the committee is not ready to make that decision now. I'll be glad to work on a standing committee of the whole amendment with the good chairman, with the committee to clarify what you want. The second thing, Mr. Chairman, is I do have the language that would go into the solid waste mass management. It comes directly out of that House Enrolled Act 68. So if the committee wanted that immediately, I have that language that could be supplied to the committee if they wanted to include it in your standing committee. If you're not interested in that, I will include it in the committee and a committee of the whole amendment should this bill come to the floor, Mr. Chairman.
So while I can't speak for the will of the committee, my thoughts kind of were to, if we like this concept, just move the bill forward and let you do a committee of the whole amendment with a cleanup with those things. So they were in just one amendment rather than trying to bring 2 or 3 different amendments forward, and sometimes that can get messy.
Thank you, Mr. Chairman. I certainly understand the solid waste management exception or definition, and all I'll need is guidance from the committee about whether they want specificity on the type of materials or how that would be. I'll give complete deference to this wishes of this committee with the preparation of the committee of the whole amendment.
I think we can, Mr. Speaker, I think we can kind of debate that and kick that around. You sit here and listen, it'll be good.
Thank you, Mr. Chairman.
All right, anyone else wishes to testify? If not, Yeah, sure. But you can't ask him about coal ports, Representative Gray.
Thank you. It's always trying to get that in. Thank you, Mr. Chairman. Was hoping to ask this earlier, so thanks for coming up again. The wind portion on the fee on page 3, I mean, I really don't have a huge issue with this bill, the tire stuff, but I don't like disposing of these wind turbines. I mean, in my community, it's been very controversial. I know it's already in statute, I guess. I think that was last year or 2 years ago. But first of all, what does this provision do? Because I just don't understand. Does it cut the fee or does it increase the fee? And 2, why did you put this in the bill? Because I mean, I'd rather just keep it to the tire issue and not get into wind turbines.
Go ahead, Mr. Speaker.
Thank you, Mr. Chairman. So it was placed in the bill because I did not want to place 25% of the revenues for the tire application. But I also like consistency in statute. Personally, I like consistency. So my suggestion is you take this out, not because I wouldn't like to lower it or make it consistent, because I don't want to impact the regulatory process that's already underway. The authorization process are already underway for the wind turbine disposal. And I certainly recognize there's difference of opinion whether you want them disposed of or not, coal mine or non-coal mine, et cetera. But the only reason, so it would have reduced the fee for the wind turbine ones that would have been payable to the state. But my request is that language actually be stricken from the bill, because I do not want to impact the current process that our Department of Environmental Quality has undertaken with the Federal Office of Surface Mining. Thank you, Mr. Chairman.
All right. Okay, we will close public testimony. Did you have follow-up, Representative Gray? Okay, all right. Okay, all right, we'll close public testimony. What's the committee's pleasure? Okay, moved by Heiner, is there a second? Second by Burkhart. So I'll just, a little chairman's prerogative. My feeling is I think maybe we can discuss this bill a little bit, but not do a standing committee amendment. And then if the speaker doesn't bring a satisfactory committee of the whole, we can swarm like appropriations and attack it. So is that okay with the committee to do that? Okay, so let's go ahead and hear comments on this bill. So Representative Duncan.
Thank you, Mr. Chairman. I would prefer to go the direction that the speaker just talked about, is that we leave it the way it is with the inert and broad, and then the rulemaking they're allowed to do based on application. That's the direction I'd like.
Representative Bear, then Burkhart.
I would second that. You know, I can foresee this particular equipment that this company has bought also working on things like belt materials. And so to narrow it down to chip tires could preclude their ability to operate.
Representative Burkhart.
Thank you, Mr. Chairman. Mr. Chairman, that follows with my comments. I would not limit it to chipped tires. There may be a reason to dispose of whole tires, or as Representative Bear said, belts, hoses. I would say something similar to rubber material.
Any other comments, Representative Gray?
Yeah, Mr. Chairman, I'd like to take out the wind turbine part, just get it done. I mean, so is there a huge objection? Do you have a huge objection to bring that amendment?
No, I don't. I was just suggesting that, but to pull that out would be fine. That would be an easy amendment, and then that's one less thing that the speaker would have to explain regarding.
All right, I'm going to move that amendment, page 3, strike, or is it the appropriate time? Sorry.
Yeah, that's fine. Let's go ahead.
Strike lines 2 through 9.
Also on page 2.
Oh, okay.
Yep.
Roman at 13.
Also on page 2, strike lines 19 through 23.
Okay, so the amendment is on page 2, Barb, strike lines 19 through 23. And then on page 3, strike lines, I guess it's 2 through 9. Is there a second to the amendment?
I'll second.
Okay, second by, we have to share with the remote delay. Any discussion on the amendment? Yeah, Representative Hunter.
Mr. Chairman, I guess I'm a little confused. I thought there would be a committee of the whole amendment to do all this cleanup, so we don't have duplicate amendments.
I think, yeah, that's what I was suggesting, but Representative Gray just wants to make sure it gets done by this committee, so I'm fine with that. Okay. Any further discussion? Question been called. All those in favor of the amendment, say aye.
Aye.
Opposed? Okay, that amendment is adopted. Okay, any further discussion?
Question.
You know, I'll just say, maybe I've been doing this too long. I was leaning with Mr. Ash on being more specific on it, but we'll let the speaker work on that. I was concerned about that definition of just how do you get that defined? We got a little bit of time to work on it. One thing is this, you know, this is really like the second step in the whole process to work it. There's a lot of time to make sure we get it right, and for the speaker to work with the agency as well and find something that'll work. So, okay. Any further discussion? If there is none, we'll go with a roll call vote on House Bill 123 as amended.
Representative Bear.
Aye.
Representative Burkhart.
Aye.
Vice Chairwoman Duncan.
Aye.
Representative Air.
Aye.
Representative Gray. Representative Heiner. Representative Sherwood.
Aye.
Representative Western. Chairman Greer.
Aye.
All aye.
Okay. Oh, it's the least we could do. Right now, I don't have anything in the queue. Knowing that we have budget amendments, I'm not inclined to call a Friday meeting for like one bill unless I see a whole bunch coming in and we need to knock one out. But we'll keep the note. We'll get a notice out as necessary, at least by 2 o'clock on Thursday, right? So, okay. All right. Thanks, committee. Meeting adjourned.